My name is Jeffrey Antonelli of the Antonelli Law. Thank you for coming. The point of my presentation today is basically to make you all advocates. As most of you know right now, Part 107 is supposed to come out shortly, and Congress is in the middle of sausage making, creating the 2016 FAA Reauthorization Act. We've learned a lot of lessons over the past couple of years dealing with the 2012 FAA Reauthorization Act. And basically, the Senate has created a version that's gone over to the House, and we have a fight. The part that I'm going to talk about today is federal preemption and why we need the express federal preemption provision to stay in. So, I'm going to talk about what Section 333 has been like for our clients and for our firm personally. And then I'm going to talk about the issue of noncompliance with 333, because that happens quite a bit, and how delays in approvals with the FAA and some other issues of trying to live with the conditions has affected our clients and ultimately our firm as a microcosm of the industry. And finally, I'm going to tell how living up to our fiduciary duty as lawyers to tell the truth to our clients and prospective clients has cost us money, at least in the short term. So, on the right side of the bill, the Senate bill, discusses the fact that it's similar in many ways to 2012 FAA reauthorization. And as of the time we created this slide, which was just early last week, Senator Dianne Feinstein of California had proposed an amendment that would take out the express federal preemption clause. But, news alert, apparently it's back in. That's why I say it's a fight. So, you undoubtedly have heard about what I'll call local drone laws. So, states and municipalities around the country are trying to say, ban drones, or restrict drones, or arrest drone operators, or you can do this and you can't do that. And many of you who are already familiar with aviation know that the FAA has exclusive jurisdiction over the airspace, or the regulation of airspace. So the question is, well, why would they bother? And I guess it's because they can. Lawyers like me, who grew up, so to speak, in litigation, get excited sometimes. We get to file a case in court. If we win, that's great. Our client wins, we look good. If we lose, we have the chance to appeal and maybe go up to the Supreme Court and make history. The problem with that is it's bad for business, it's bad for the industry, it's slow, it gives uncertainty, and we'd rather have clarity and create business. So, at the end of last week, basically, the Senate had concluded and voted it out, and it's going to the House. And the House had their own act, called the AIRR Act. And they're going to discuss it, and there's going to be a conference. And this is the time where we need you to reach out to your elected representatives. And if your organization is fortunate enough to have access to a lobbyist, to give them a call and say, we need your help. So in the Senate Act, this is the express federal preemption. So it basically says that, I'll just read this here, this is from the Senate Guide. This section would establish a federal preemption for state and local laws relating to the design, manufacture, testing, license, and registration, certification, operation, or maintenance of a UAS, including airspace, altitude, flight paths, equipment, or technology requirements, purpose of operations, and pilot, operator, and observer qualifications, training and certification. Boy, that's a lot. And then they will basically allow states to do what they've always been able to do, which is pass laws pertaining to privacy and trespass. But I'm going to talk to you why this is so important. Because if it's not in your own backyard, you may not pay attention. Well, being in Chicago downtown for so many years, I paid a lot of attention to the Chicago drone ordinance. So, by the way, that's a picture I took of my DJI Inspire on the right. They look pretty good in Chicago. So, the Chicago drone ordinance says, okay, if you have a Section 333, we're hands off. But otherwise, if you don't follow it, you can be arrested by Chicago BCOP. A fine of $500 to $5,000. This is for flying anything. Seizure of your UAS, storage fees of $20 per day, in prison, up to 6 months. What could get you in trouble? Flying after dusk, flying over a church, flying over property that you don't own and don't have permission. Again, that should be scary to you if you've been in aviation. Now, because they say you cannot fly over property you don't own without permission, my question was, let's go back, was the Chicago Park District. So when I flew that picture, I took off from Northerly Island, part of the Park District. You may have heard of Meigs Field. That was where Meigs Field used to be on Chicago's lakefront. And our former Mayor Daley II decided, you know what, I don't want it to be an airport anymore, I want it to be a park. So he had heavy equipment go in the middle of the night. GA aircraft were on the field. They tore up the airstrip, put a couple X's in, and that was it. No notification to the FAA. Chicago has the Chicago way. So we contacted the Chicago Park District, and you're going to see an interesting video in just a moment. And I'm not sure why this has my hand. So the Chicago Park District, in order to give you permission, they say we'll give you a permit to fly your RC model airplane or your Phantom, your DJI Inspire like me, but they're not giving out any. I mean, this is flying level. So it's a de facto ban. What's the penalty under the Park District? We've got a gremlin here, by the way, in the computer. It's $500 per day fine. What else is illegal? Anything with FPV. So this will get you arrested, literally. It doesn't matter what size, it doesn't matter the altitude. This will get you arrested. Chicago Beat Cop, I mean, they don't have anything to do with airspace. I mean, I grew up, my grandfather, my great uncle, two of my uncles were cops. I know the stories about cops. I don't want them making decisions. So I'm going to try to play this video, and you're going to recognize the person capturing the video from a low altitude that I really enjoy.
Check out the stunning views he captured earlier this year along the lakefront. These are images he says he may not be able to get again thanks to new drone rules.
You can fly one of these things in areas that are absolutely safe, and we've been doing all year, and you can be arrested. That's very concerning. So they call the Park District and say, oh sure, the Park District says go ahead and fly.
And we checked in with the Chicago Park District. It says it's still working on specific drone rules for flying at its parks, but in the meantime, you can fly at Chicago parks. Just keep in mind, if staff ask you to stop because you're creating a safety hazard, you have to stop.
So let's see what local drone laws are like in practice.
Rowe loves to capture amazing views of the city with his drone.
I enjoy flying. I've always liked flight.
Last week, he was flying at the Chicago Park District's Northerly Island when a security officer told him he had to stop.
He comes back to me and says, hey, well, do you have a permit for this? And I'm like, well, I apologize, sir. I wasn't aware of, having, a permit to fly at any of the Chicago parks.
It's another incident that demonstrates the confusion among drone enthusiasts and law enforcement about the actual rules.
I don't want to break any laws or anything like that, so, I brought it down, and that was it.
So, local drone rules in practice. It's a scary thing. So back to preemption. So probably most of you have seen the memo on preemption from the FAA. And this was given out nationwide. I think I'm hitting the mouse. Basically, it was an instruction booklet for, as I view it, local governmental agencies and state officers, the lawyers anyway, to say, look, the FAA has exclusive jurisdiction over airspace, and then here's why. And they give lots of statutory and case studies. So preemption exists even without the FAA Authorization Act. But again, getting back to what I was talking about before, do you want to have lawyers like me fighting in court, having different judges in different states and different judicial federal districts making decisions that conflict with one another, and when you just want to fly and have business? So my point today, again, is to make you all advocates that in the FAA Reauthorization Act, we need an express federal preemption provision. make it clear, so maybe you or your lawyer can send it to your state senator or your local councilwoman and say, here it is, black and white, it's clear. Please don't pass this law or please rescind it. Otherwise, we have to do the things that I went to law school for, meaning drafting pleadings and cases and arguing before judges, and it's really not what we want. Some other tidbits going into the FAA Reauthorization Act. There's some nice tidbits about privacy. Privacy is something that I've been talking about for a while, and not only in terms of, hey, your drone's flying over my backyard and you're taping my daughter and that sort of thing, but I've been interested in questions about who owns the data. And the government is proposing to address that in some sense. So my example I usually talk about when I say who owns the data, if you're overflying one farmer's field and you go over someone else's farmer's field who's not your client, and you're able to read interesting data, and there's Monsanto seed over here and someone else's seed over here, that data is probably pretty valuable. Who owns it? The interesting thing that I saw, this is being cut out here, is not the FAA, but the FTC is going to be in charge of enforcing commercial policy, commercial privacy policy. That was a bit of a surprise to me. Other parts of the Reauthorization Act talk about the NTIA, which most of you are probably been keeping track of, and some other sections talking about governmental operations, intergovernmental cooperation, that sort of thing. Safety standards. Doug Marshall's going to be talking today about safety standards, so I don't want to get too much into it. But basically, as someone once told me last year when we were talking about the industry, the hobby needs to grow up. We can't have hardware failures, small little hinges on an aileron that cause things to crash and cause a personal injury, and software that's not certified. So these standards are coming. So if you're working in the industry now, you should be aware. Section 2126 I found pretty interesting. So again, this is the Senate version. Section 333 is going away, sort of. We don't know exactly what this is going to be, but it's clear that Section 333 is going to continue in some form. In this section, Congress is explicitly telling the FAA, you have the authority to give exemptions for nighttime operations and beyond line of sight. If you think that's a good idea, call your congressman. We want the FAA to be able to do these sorts of things. Something else I'd like to have the FAA be able to do is give emergency COAs. We have people all across the country that are certified airmen. They have 333s, and they could be of use in emergency operations. We don't want them creating a problem, as Gene Robinson was discussing, but if your local fire department were to ask you, could you help? You wouldn't be able to, unless you're flying under their COA, because of the no tampering. Section 2155. If any of you have any experience or working with higher education, this is something that's been very frustrating to me personally. I've had faculty members coming to me over the last year saying, we want to create a drone program, either just for operators or maintenance or dealing with the data, we want to fly. And unfortunately, we've had to tell them, well, do your students have manned pilot's licenses? And of course, the answer is no. The faculty don't, at least not most of them. So what we would like to see in the final reauthorization is a streamlined approach where higher education can fly unimpeded by the red tape that we currently have. And I think we need to grow the industry, and higher education, I think, plays an important role. So what can we expect from future FAA exemption petitions, like the outline on the side of nighttime operations? Obviously, Section 333, although it's been a bridge or a first step, there's been horrible delays. We have clients that are losing hundreds of thousands of dollars because they're still waiting for approvals that were filed back in September. So I wanted to talk a bit about what we saw. So first, there's been over 12,000 petitions in the FAA. More than 4,900 petitions and amendments have been approved. And it's widely believed that between 80 and 90% of 333 operators are not compliant. Either A, because nobody in the company has a manned pilot license. As someone from the FAA said, they have people calling up and say, I have my 333. What's a PIC? Yeah. Or two, they can't possibly comply with the 333 conditions. Usually it's the 500-foot rule from non-participants. It's very difficult to do this. Now I want to talk about what my firm's personal experience has been. And I say this, usually I don't reveal things about my firm's experience, but I want to do so because I think it mirrors a lot of what my clients are experiencing, what the industry is in general. And that's because of what I think is some ridiculous red tape and ridiculous requirements. We suffered because as lawyers we have a fiduciary obligation to tell the truth and to inform people of what is it going to be like to have to live with a 333. Over the past year and a half or 2 years, we have talked to about 800 people saying, I want a section 333. Great, let's talk about it. Free consultations. And I get around to telling them, oh, and by the way, you have to have a manned pilot license. Either yourself or you have to hire someone. Really? No, really, let me show you on the FAA website. I'm not going to bother. Drop off. So about 100 people hired us, and we're grateful for it. Next I want to talk about living with the 333, top client gripes. First is site-specific COAs. You wanted to fly beyond 200 feet until recently, you need a site-specific COA. One client said, well, we want to inspect refineries and other industrial plants, hundreds of them across the country. How do we do this? You need a COA for each one. Really? We don't need it today, but we need to fly that. Yes, we need a COA. How long does it take? Somewhere between 2 and 8 weeks. So we can't wait that long. That's what the FAA is. Second is that whenever something has come out, and as most of you know, the 333 is continually evolved. But the new rules that become beneficial, that most of us are grateful for, are not retroactive. So, for example, I remember when Doug Trudeau, the first realtor in the country to get permission to fly into Section 333 happened, and that made national headlines. And he was located in Tucson. I know Tucson. My family has some desert land there. And I really like it. There's beautiful shots in the Catalina foothills, nice expensive properties. Oh, but there's a prohibition in the 333. You can't fly anywhere it's yellow in the sectional chart. Well, that's all of metropolitan Tucson. So it was a worthless grant of exemption. Now, that went away. But Mr. Trudeau didn't get the benefit of that new rule being applied retroactively to his, and then he had to file his own amendment. It's a very frustrating process. Similarly, what I call the kitchen sink is the new 1,200 or so UAV approval. If you get approved today, the FAA says, under number FAA 2007-3330, oh, you can fly any of these. Well, that's great. Well, what if you got approval to fly an Inspire and a Phantom 3 months ago? Is it retroactive? No. It doesn't make any sense. So now you have to go file another amendment to add any of those or all of those from the so-called kitchen sink, excuse me. And the FAA has to deal with that. We really don't understand. And then here, competing operators not following the rules with little risk of getting caught. I hear this all the time. So people file their 333, they pay for the insurance, workers' compensation, they're filing their flight plans, they're hiring a lawyer, and then, they get underbid by the guy who does nothing. They're very, very frustrated with that. And then I already talked about the conditions and limitations. Next in our experience with 333, I talk about clients' needs post-approval. A lot of people need help with living with the 333. I have a cinematography studio who asked me to just review their footage and see, is this okay? And I have to say most of it looked beautiful. It was stunning footage, but it was all illegal. So No, don't release that. I already mentioned about larger clients needing hundreds of COAs across the country. Makes it very, very difficult. Service contracts, a lot of people who are new to drones who wanted to supplement their income because they still don't have as good of a job today as they had before the recession, so they thought drones is for me. They don't know anything about business, how to protect themselves. We're usually telling them, well, do you have an LLC or a corporation? Well, no. Okay, do that. And when I'm talking about the 333, I always tell them, well, yes, here's the law you have to have, but the more important is to get insurance. And it has to be insurance that's going to cover commercial UAV operations. People need a lot of help. Intellectual property protection, anything from copyrights to patents and trademarks, and then again, limiting liability in the event of an accident. Patrick mentioned that we don't want to go too long. We made a lot of slides. I just wanted to point out some of the different changes that happened. So the first 7, or the Hollywood 7, had extensive conditions. A private pilot license was required, separate COAs for each operating site. Then that changed to the summer grant process, changed from private pilot to sport pilot. No notice and comment was necessary. That's when the bar started being for the 333 exemptions. First we had a blanket COA of 200 feet, then moved to 400 feet. I'm going to skip over these, just in the interest of time. And then, of course, aircraft registration. For the past year and a half, I've always included N number registration as part of our 333s. Not because we like it, we don't. It was an absolute pain, but we didn't want clients going through that. We wanted to make sure they got in the air. Finally, as most of you know now, you can go online for your commercial registration. Looking ahead, again, my hope today is that you're going to become advocates and engage with Congress, because this is the opportunity now to make business favorable in the future. Nighttime operations, above 400 feet, beyond visual line of sight flights, operations over non-participants, that will be discussed later today, operations without a manned pilot license. Most everyone believes that Part 107 is going to include a new pilot license, not manned pilot license, but a drone operator airman certificate of some sort. We don't know what the restrictions are going to be, but I think this is time to engage your congressman or congresswoman and talk to them. Again, it's been very, very difficult for business to comply. And I want to make mention of my general view of 333, which is that the bar has been so high with the manned pilot license, it's encouraged people to slide right underneath and not comply with anything. And I think that's bad policy. I've likened it to prohibition. So back when alcohol and booze production was prohibited, people were making bathtub gin. And what was wrong with bathtub gin? People went blind and people died because there was no education. Things we think we're going to do after Part 107. Well, we think we're going to be involved in litigation attacking local drone laws. Then we hope express federal preemption is going to be there in the re-authorization, so it'll make our work easier. FAA enforcement defense, beginning of this year, we started seeing people being gone after for violating FARs by FAA. We hadn't seen that before. Exemptions for drones heavier than 55 pounds. So some of our people, there's myself, Mark Del Bianco, he's my regulatory hotshot in DC. Kate Fletcher is a lawyer I've known for over 10 years. She's a pilot in American. And of course, Mr. Marshall is our consultant. These are some of our clients. And I want to end with what I think is one of the coolest helicopters I've seen. Mike Conradi of iChemcopters, we got this approved for him. It's a really cool cinematography drone that can stay in the air for an hour carrying heavy lift type of cameras. So if you have any questions, here's my contact information. Thank you very much.
Test. We're a little behind, but any questions? Oh, jeez.
I haven't used up my quota yet.
That's right.
Jeff, thank you. Great presentation. I have several clients that I'm consulting with, including some airport authorities and airport planners. And I just kind of want to get your opinion what appears to be a conflict with regard to preemption on one hand, which I fully support, by the way, and on the other hand, where the FAA says reach out to law enforcement, and law enforcement shall provide information to the local flight standards district office. They've given handouts of a policy statement that they've issued to law enforcement.
Right.
But yet then, how does a city or a municipality give the authority for local law enforcement to operate in that means? And I think I see a conflict there in trying to resolve that.
When you mean local law enforcement operating, do you mean flight operations, or do you mean acting as an enforcement officer of
Acting
the
as
FAA?
an enforcement officer for the FAA, providing information back to the FAA as the FAA requested. So, yeah, it's a, catch-22.
At this point, I think the answer is going to be in litigation. Remains to be seen.
So, yeah, I think it's an important issue that needs to be addressed. I mean, I'm not sure how the FAA can say, can't issue an ordinance, don't issue a law, my trump card trumps yours. But at the same time, local law enforcement, please help. We don't have the aviation safety inspectors to go out and do our job, which they don't. And they do need some help in trying to take enforcement action where I call it the gentleman says, hold my beer and watch this, wants to fly, and they just simply don't comply.
I think it's a complicated question, but it's one that risks the ability of FAA to complete its mission in enforcement. Do you get the charges thrown out? Maybe.
Yeah, I just think it's something that needs to be addressed. I just wanted your input. Thank you.
Any other we got a quick question here from any of the VA guys.
I'm trying to make it quick. A lot of people, including yourself, have talked about the damage being done to the industry by road operators who don't follow the rules. What I've yet to hear is any kind of a viable solution or strategy. Any thoughts on that?
I was asked this just a couple days in an interview. I mean, obviously it's a daunting challenge. One of the ideas I had, and I'm a lawyer, I'm not a policymaker, at least not yet, is to do something like qualify the operator. So first, when you buy the drone, you can't fly it yet. You need an activation code. In order to get this activation code, you have to have an online test and test your knowledge. Okay, that activates the drone, and you can have some very limited flight abilities. Then you have to fly certain patterns, if you will. That successfully done gives you another access code that enables more altitude, more speed, maybe waypoints, that sort of thing. That's my idea so far. But it's a complicated problem. I mean, there's always going to be rogue operators, right? But I think having a buy-in in terms of the need for education is something that I think can be successfully accomplished.
And for operators, for the existing community, what do you tell your clients if they ask you, should I be dropping a dime to the local Vizdo or leave it alone?
Well, people have asked us to drop a dime, and I'm not in that business. But if someone were to do something that was actually engaged in behavior that would be threatening to life, let's say they want to fly or are flying into the airport space, like right off the runway at Midway, I would drop a dime because, that's extraordinarily dangerous. Outside of that, I'm really not sure what to do.
All right,